Hi, everyone. I'm really pleased that you decided to join me to take a look at U.S. history. We try to take a look at U.S. history from a variety of different angles, try to identify the story behind the story. Sometimes we try to look at the odd things that have happened, and certainly examine the personalities that have made the American experience so unique in all the history of the world. In particular, we take a look at the U.S. Constitution, this wonderful document that has governed this country for well over 200 years. And we try to understand some of the complications and some of the problems that we face as a nation, day by day, year by year, month by month. In any event, I hope you're enjoying this and that you come back often because I will keep repeating these and posting them to YouTube so that you can relive the experience if you want to do it more than once. And I hope you do. Anyway, welcome and enjoy the presentations. We're still in Black History Month, and so we're going to continue to take a look at what happened in the civil rights movement. Especially, we're going to take a look at what happened in the latter part of the major civil rights movement, a movement that is never probably going to be fully finished. Civil rights movement was a very chaotic, a very difficult time for everyone. 1960. Let's take a moment and pause on the 14th Amendment. 14th Amendment, first of all, part of it says that it's really to counteract Dred Scott that was passed by the Supreme Court in 1857, which said that black slaves could not be people, they could only be property. And so it does that in the beginning of Section 1. Then it talks about the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law. We are a nation as a rule of law, nor deny any person within its jurisdiction the equal protection of the laws. And these are the particular provisions that have been applied substantially and frequently to the civil rights movement. The question ultimately boils down with the court to what are enumerated versus non-enumerated rights. What does the Constitution specifically say? And that's where we get to originalism and textualism, and we'll talk more about that in a moment. Also mindful, we should be mindful about the Fourth Amendment, which says that people should be secure in their particular property, and warrants shall issue, but upon probable cause, supported oath by oath or affirmation, and particularly describing the place to be searched, the person or things to be searched. A very important key here in one case. Now let's start off by talking about Mapp versus Ohio. Now, what happens when the police obtain evidence from an illegal search or seizure? And yes, the police can and sometimes have done that. Police, in this case, had received a tip that a bombing suspect might be located at Dollree Mapp's home in suburban Cleveland, Ohio. When the police asked to search her home, Mapp refused unless the police produced a warrant. The police produced a piece of paper as a fake warrant. After searching without finding the bombing suspect, the police discovered sexually explicit materials and they arrested Mapp. Mapp was convicted of possessing obscene materials. She appealed her case on the argument that she had a First Amendment right to possess the material. The court held that evidence collected from an unlawful search should be excluded from her trial. Justice Tom Clark's majority opinion incorporated the Fourth Amendment's protection of privacy using the Due Process Clause of the 14th Amendment, and at the time this was very revolutionary and has implications for later rulings by the Supreme Court. The Sixth Amendment needs to be mentioned also because at the end of it, it says that to have the assistance of counsel for his defense. Now, that becomes relevant in Gideon versus Wainwright. 1963. Before 1962, indigent, meaning poor Americans, were not always guaranteed access to legal counsel despite the Sixth Amendment. Gideon, a Florida resident, was charged in Florida state court for breaking and entering into a pool room with the intent to commit a crime. Due to his poverty, Gideon asked the Florida court to appoint an attorney for him. The court declined to do this and pointed to state law, which said that the only time indigent defendants should be appointed an attorney was when charged with a capital offense. And so Gideon represented himself in trial and lost. He argued that he had a constitutional right to be represented with an attorney. A unanimous United States Supreme Court said state courts are required under the 14th Amendment to provide counsel in criminal cases to represent defendants who are unable to afford to pay their attorneys, guaranteeing the Sixth Amendment similar federal guarantees. Word about umbra versus penumbra. The umbra is the innermost and darkest part of a shadow where the light source is completely blocked by the occluding body. The penumbra, from the Latin pene, means almost or nearly, is the region in which only a portion of the light source is obscured by the occluding body. An observer in the penumbra experiences what can be called a partial eclipse. Now, this becomes important in law, and we'll mention here in a minute why. Griswold versus Connecticut. Again, if you have lights in front and behind you, you get a really dark shadow. That shadow is an umbra. Flanking that dark shadow are half shadows, not quite as dark, but darker. These shadows are penumbras, used to explain the most controversial issue of arguably one of the most controversial Supreme Court cases in the 20th century. Estelle Griswold was the director of Planned Parenthood Clinic in Connecticut. She was arrested for violating a statute that prohibited counseling and prescription of birth control to married couples. The question was whether the Constitution protected the right of married couples to privately engage in counseling regarding contraceptive use and procurement. Justice Douglas said that although not explicit, the penumbras of the Bill of Rights contained a fundamental right to privacy that was protected by the 14th Amendment's Due Process Clause. Griswold's right to privacy has been applied to many other controversial decisions, such as Roe v. Wade. More about that in a minute. It remains the core of the substantive due process debate today. So, a word about originalism versus textualism. 2023, Dobbs versus Jackson Women's Health Organization explicitly rejects the notion that abortion constitutes a protected liberty under the 14th Amendment's Due Process Clause. It states that the Due Process Clause only protects rights that are deeply rooted in a nation's history and implicit in the concept of ordered liberty. And there is no statement in the Constitution that deals with the question of abortion. So they decided to overturn that law. So such an interpretation, this is why it's really significant, could threaten the viability of other landmark Supreme Court decisions that, based on similar concepts of liberty and equal protection under the 14th Amendment, establish rights that were not available during the American Revolution. And so what do they include? They include stuff like Griswold versus Connecticut that guarantees a right to use contraceptives, Loving versus Virginia, more about that in a minute, that invalidated states' bans on interracial marriage, Lawrence versus Texas in 2003 that banned state sodomy laws, and Obergefell versus Hodges in 2015 that recognized a constitutional right to same-sex marriage. If you are going to go back to this originalism and textualism, you could very well rule that those all must be overturned and thrown out. Loving versus Virginia. By 1967, 16 states had still not repealed their anti-miscegenation laws that forbid racial marriages. Mildred and Richard Loving, who have passed away by now, were residents of one such state, Virginia, who had fallen in love and wanted to get married. Under Virginia's laws, however, Richard, a white man, could not marry Mildred, a woman of African American and Native American descent. The two traveled to Washington, D.C., where they could be married, but they were arrested in Virginia under a state law that prohibited interracial marriage. Because their offense was a criminal conviction, after being found guilty, they were given a prison sentence of 1 year. The trial judge suspended the sentence for 25 years on the condition that the couple leave Virginia. On appeal, the Supreme Court of Appeals of Virginia ruled that the state had an interest in preserving the racial integrity of its constituents, and that because the punishment applied equally to both races, the statute did not violate the Equal Protection Clause of the 14th Amendment. The United States Supreme Court, again in a unanimous decision, reversed the Virginia court's ruling and held that the Equal Protection Clause required strict scrutiny to apply to all race-based classifications. Furthermore, the court concluded that the law was rooted in invidious racial interest. The Loving decision still stands as a milestone in the civil rights movement. And it will be interesting if it ever is considered again by the Supreme Court, because Justice Thomas is involved in an interracial marriage himself. And so it would be interesting to see how they handle that. Regents of the University of California versus Bakke. 1978, Alan Bakke, a white man, had been denied access to the University of California Medical School at Davis on 2 separate occasions. The medical school set aside 16 spots for minority candidates in an attempt to address unfair minority exclusion from the medical school. Bakke contested that his exclusion from the medical school was entirely based as a result of his race. The Supreme Court ruled in a verily divided plurality that the university's use of strict racial quotas was unconstitutional, and ordered that the medical school admit Bakke, but also said that race could be used as one of the several factors in the admissions process, just couldn't be the only reason. It's important to note in the whole question of civil rights that television played a huge role, because television came into our living rooms. It exploded during the 1950s, and so by 1960 and into the 60s, everybody was watching every night things that were happening. They had sit-ins that began in this period. February 1, 1960, the first one was at the Woolworths in Greensboro, North Carolina. The plan was that they were going to remain seated until they were served or arrested. There were about 65 seats, by the way, at this counter. And here you see the African American students sitting and trying to be served. And here they are seated, and they're dumping food and drink on top of them in order to harass them. The protest soon spread throughout North Carolina and eventually to 26 southern cities. And here are a group of pictures, one after the other, that you would have seen on television during the 1960s, showing the different elements of the civil rights movement and the protests that were going on. This one is particularly poignant because you have what appears to be a very nice, educated, well-dressed black woman protesting, and black cops, or white cops rather, with their nightsticks there. Sad. Anyway, this is a parading of "I am a man" in front of the soldiers. And another one where a black and a white person are seated at the counter. The little girl who had to be escorted to school by federal marshals. And of course, the ever-present segregated water fountains. And of course, this classic picture was the dogs being sicked on protesters. And this was on our television at night, and it made us sick, and it made us angry, and it changed the civil rights movement substantially. And just to remind everyone, it was not only blacks who were being discriminated against, there were Spanish and Americans, and there were also Asians as well. Any minority group faced discrimination. I love this picture because in 1962 I drove across the state of Arkansas and I actually saw homes that looked almost identical to this one. You could literally, from the road, look and see through the cracks on the side of the building the daylight on the other side. People were living in great, great poverty. Now, sit-ins were also successful in defeating segregation in public parks and swimming pools and theaters and churches and libraries and museums and beaches. It was making a huge difference in many different places all at once. Most of the protesters were students who were impatient with the slow progress, idealists. They formed the Student, and it's important that word, Nonviolent Coordinating Committee, SNCC. They believed that if Northern white America was shown on television nonviolent responses to police brutality, the movement would gain momentum, and it did. Eventually, the authorities caught on. The brutality continued, but only practiced behind closed doors away from the cameras and media, although it is left today. SNCC's purpose was to provide a voice for students in the civil rights movement. The main goal was to give blacks political efficacy by registering voters. It joined with CORE to organize the Freedom Rides, Freedom Summer, the Freedom Schools, and the Mississippi Democratic Party. They concentrated on registration, organized the Voting Rights March from Selma to Montgomery. There was tension because this Southern Christian Leadership Conference, led by Martin Luther King, would sometimes arrive and take credit for what was happening when it was really SNCC or SNCC that was doing what was happening. In 1966, Stokely Carmichael took over and he transferred the organization more into black power. He ejected whites from the organization and it began to become, and they changed the word nonviolent to national, and another leader later on, Rap Brown, wound up going to prison and the organization eventually disintegrated. In October of 1966, Martin Luther King was arrested during a sit-in in Atlanta. Because of the major media coverage, both presidential candidates were pressured to take a stance. Kennedy called King's wife and helped to arrange his release from jail on bail. As a result, blacks began to believe that Kennedy would help them gain equal rights. Kennedy did receive 70% of the African American vote in the 1960 presidential election. Up until then, blacks, thinking back to Lincoln freeing them, at least supposedly freeing them, had voted Republican. And now they became more Democrat. And today, if I recall the numbers correctly, about 85% of African Americans tend to vote Democrat. 1961. There were these marches throughout the South, and there were many of them, and they were very effective. And they were students who were going out to try to make a difference, but at a cost. The purpose of the Freedom Rides was to bring the civil rights movement to the deep South states, especially Alabama and Mississippi, where white resistance to desegregation was the strongest. You see here, during the Freedom Rides, protesters were met with violent hostility from local whites. Below you see one of the buses that's been bombed and is burning. And this we were seeing on television at night. Students John Lewis, who was a aide of Martin Luther King and he later served in Congress for many, many years effectively, and James Zwerg during the Freedom Rides. Zwerg in particular was beaten almost to death for his participation. He was bloodied very, very badly. The Ku Klux Klan was issued more than one restraining order to prevent them from interfering with interstate buses during the spring and summer of 1961. And by the way, the Ku Klux Klan still exists in many places around the country, but it's not nearly as effective because they were put in court and sued so many times that the financial obligations finally wrecked them as a national organization. Albany, Georgia. During the Freedom Rides in December of '61, a small group was arrested while protesting outside the segregated train station. Local leaders organized several marches and rallies. The rest of the month, Martin Luther King Jr. arrived and was arrested, along with others. Although hundreds were arrested and the protests lasted for months, white city officials refused to negotiate and closed the public facilities instead of integrating. The lack of success led to frustration on the part of students who now advocated a more radical approach than Martin Luther King's nonviolent approach had advocated. So 1962 rolls around. Council of Federated Organizations created by local Mississippi activists, along with other organizations. Early in 1963, they organized a freedom vote to register blacks to vote. It was done to send a message to the state and federal governments that African Americans were going to vote and participate in the political system. They held a mock gubernatorial election in 1963. They helped to organize the Mississippi Summer Project, in which they beat people out to register and become active and to vote in the 1964 election. Voter education program. As a result of the escalating violence towards anti-segregation protesters, the federal government encouraged voter registration as a less controversial method for achieving desegregation. And Robert Kennedy got involved in doing this, and this man called Wiley Branton, who had also been the counsel for the Little Rock Nine. And during this period, more than 650,000 African Americans were registered to vote in 11 southern states. It began to make a difference. It began to turn things upside down. James Meredith, you remember this guy? He applied to the University of Mississippi, which was an all-white college, in January 1961. One of his many letters here that demanded his application be accepted for admission. Governor Barnett was opposed to integration and tried to block Meredith's admission. Meredith, with the help of the NAACP, obtained a court order to be admitted to the university. He was escorted by federal agents after rioting ensued on the campus. What's kind of ironic is that Mr. Meredith, even though he was ultimately involved in a civil rights movement, and supported by Democrats, was in fact an ardent Republican and later ran for office as a Republican in Mississippi. 1963, Medgar Evers, leader of the NAACP in Jackson, a really good guy, the first one to be assassinated. He investigated crimes against African Americans in Jackson and led boycotts. American civil rights activist, the NAACP's first field secretary in Mississippi, was assassinated by a man by Byron de la Beckwith. Remember that name? Evers was a decorated U.S. Army combat veteran who had served in World War II, and he engaged in efforts to overturn segregation at the University of Mississippi and the segregation of public facilities and the enforcement of voting rights. All white juries in 1964 deadlocked on de la Beckwith's guilt and failed to reach a verdict. In 1964, black people were disenfranchised and could not vote or register, and they were also excluded from juries, which came from a pool of registered white voters. De la Beckwith was convicted of murder on February 5, 1994, 30 years later, and sentenced to life in prison after having lived as a free man for much of the 3 decades following the killing. In 1997, de la Beckwith appealed his conviction in the case, but the Mississippi Supreme Court upheld it, and the U.S. Supreme Court declined to hear it, and he died at the age of 80 in prison in 2001. So at least he served a few years for his crimes. Birmingham, Alabama was one of the most segregated cities in the South, and the purpose of many of the sit-ins and boycotts was to end segregation there. This attack by police dogs on protesters got the movement much needed press coverage, and we all saw this. In April, city officials were able to get a court order blocking the demonstrations. Martin Luther King was arrested in Birmingham for defying the court order blocking the protests. He wrote his famous letter from Birmingham jail to local white ministers that had called King a troublemaker. And it would be good if you could have a chance to read his famous letter from Birmingham jail. It's a marvelous statement. Eugene Bull Connor, another name you remember from this period, was the police commissioner of Birmingham who openly opposed integration. After the televised images of police brutality against protesters garnered northern white sympathy, Connor ordered that violence only be practiced out of the spotlight. Governor George Wallace brought in Alabama state troopers to confront the protesters. He opposed ending segregation and used all of his gubernatorial powers to prevent it from happening. This shows Wallace blocking the entrance to the school and his forced removal to allow integration. There's a page from notes taken by Robert Kennedy on events in Birmingham, and it's interesting to read, but you can't do very well here, but I will say his penmanship was terrible. There's another letter from a little person, a child, in asking John F. Kennedy to send troops to Birmingham. People knew that they needed the federal government to intervene in this situation. In May 1963, after more than 1,200 people had been arrested, white leaders finally agreed to negotiate. Birmingham was to be desegregated, including lunch counters, restrooms, and water fountains, in exchange for an end to the demonstrations. Kennedy sent in federal troops to help restore order. This event helped to motivate civil rights volunteers. You see, people saw, now we are making progress. We need to keep moving on this effort on our part. JFK announced to the country that the situation had been stabilized. January 1963, Kennedy met with civil rights leaders who informed the president they were going to hold a peaceful demonstration planned for Washington, D.C. Do you remember A. Philip Randolph, the head of the Porters Union? He had planned to have a similar march in early 1940s, and Roosevelt talked him out of it. But this one they were not going to talk Kennedy out of. Kennedy tried to discourage the march because of possible violence. The March on Washington for Jobs and Freedom, August 28, 1963, one of the really important events in the whole civil rights movement. More than 250,000 people gathered at the Lincoln Memorial. It was an incredible gathering, a peaceful gathering, I might add. The marchers represented a broad spectrum of interests. The protesters wanted federal legislation to outlaw segregated facilities. And there were many protesters there from all kinds of organizations. It was not only the ones who were black or minorities, it was also the labor unions and the teachers unions and other kinds of groups in the country. And it was televised. That helped to make it one of the most important demonstrations of the civil rights movement ever. Many famous people were present, and some of them performed. Marian Anderson, Mahalia Jackson, Sammy Davis Jr., Joan Baez, Bob Dylan, Peter, Paul and Mary, Odetta, the Freedom Singers, and I Am a Civil Rights Marcher. Then 1964, Reverend Martin Luther King Jr. and Johnson discussed civil rights legislation, and this led to the Civil Rights Act of 1964. The bill was introduced to Congress in 1963 prior to the March on Washington. Kennedy was trying to push through the legislation when he was assassinated, and arguably he might not have been successful in getting the legislation enacted, but he died and he became a martyr. Lyndon Johnson was, of course, effective in dealing with the Congress, and so he was able to use his influence in Congress to help get it passed. The Civil Rights Act of 1964 required uniform standards for voting and abolished literacy tests. It made racial discrimination and segregation in public places, such as theaters, restaurants, and hotels, illegal. It outlawed discrimination in any federally funded program or job, including discrimination based on gender. The Mississippi Summer Project, organized by the Council of Federated Organizations. Many Northern white students volunteered. They registered voters and eventually encouraged them to vote for the Mississippi Freedom Democratic Party, which was the rebel party trying to represent the state of Mississippi's regular Democratic Party. The volunteers set up freedom schools to raise awareness of the inequities of the education system. Here's an important event. This is an FBI poster advertising 3 missing volunteers: Andrew Goodman, James Chaney, and Michael Schwerner. June 11th, '64, the 3 men set out to investigate a church bombing near Philadelphia, Mississippi. After being arrested for a minor traffic violation, the men were held in jail, which is the last place they were seen alive. Their bodies were found 6 weeks later. Both white men were shot in the chest, while Chaney was brutally beaten to death. 1967 trial, no one was ever convicted of murder. They were only convicted of interfering with their federal civil rights because all white juries refused to bring back a murder conviction. And so almost 20 years later, January of 2005, a Neshoba County grand jury indicted Edgar Ray Killen on 3 counts of murder. And of course, it went through to trial, and he was convicted. The jury convicted Killen on 3 counts of manslaughter. It's described as the man who planned and directed the killing of the civil rights workers. Killen was already 80 years old and was sentenced to 3 consecutive terms of 20 years in prison. His appeal, in which he claimed that no jury of his peers would have convicted him in 1964, based on the evidence presented, was rejected by the Mississippi Supreme Court in 2007, and he died in 2018, 6 days before his 93rd birthday. Nevertheless, he did serve 13 years in prison for his murder. The Freedom Schools, taught primarily by Northern white college students, most African American children worked in the fields with their families and therefore did not attend school. Hard to believe, isn't it, that they were uneducated? Although by 1963 state funding for education had basically equalized, local school funding was extremely inequitable to black education. The curriculum included basic education, learning to read and write, something about African history, African American history, government, voting procedures, and other topics. The Mississippi Freedom Democratic Party was organized in 1964 to change the Democratic Party, which was denying access to the black citizens of Mississippi. Membership was open to all, but of course was primarily black. They attended the 1964 Democratic Convention in Atlantic City, said, "We want to represent Mississippi." Well, that didn't quite work. They supported LBJ, but traditional white Democrats threatened to support Republican candidate Goldwater if LGB helped this Democratic Party rump group. They were offered some seats at the convention, but because so few, they would have no real power, so they declined. Even though it was a technical defeat, it became a turning point in civil rights because it helped to lead to the concept of black power. And he was the leader of it, Fannie Lou Hamer, at the Democratic Convention in 1964, just a prelude to the 1968 convention, which became in Chicago, which became very, very wild and active for changing things, including civil rights. Malcolm X, a black Muslim black activist. In 1964, he gave a famous speech called the Ballot or the Bullet speech. He advised African Americans to judiciously exercise their right to vote, but he cautioned that if the government continued to prevent African Americans from attaining full equality, it might be necessary for them to take up arms. You probably never heard this speech, but it was ranked 7th in the top 100 speeches in the 20th century by leading scholars of American public address. Malcolm X began his activist career by preaching black separatism. He felt that blacks should not try to fit into white society. Instead, they should focus on developing their own communities and economic structures. He also believed in using violence to achieve these goals if necessary. In 1964, Malcolm X made a pilgrimage to Mecca as dictated by his Muslim beliefs. On this trip, he came to believe in the brotherhood of all races and changed his stance on separation between blacks and whites. He broke away from the Nation of Islam and worked with people of all races. And we have the advent of the 24th Amendment in 1964, which removes the poll tax. In most of the South, they had required that in order to vote, you had to pay. And that is now removed, and it's in our Constitution that you cannot do that. And it was the beginning of the removal of things earlier, the literacy tax and other requirements and so forth, too. 1965, Malcolm X was assassinated while giving a speech in 1965. 3 gunmen were arrested and convicted and were believed to be Nation of Islam members, although the record and so forth on all of this is still muddy today. A march was organized by SCLC from Selma to Montgomery. This is the Southern Christian Leadership Organization. This is Martin Luther King's organization. March 7th, 1965, and they demanded fairness in voting registration. Demonstrators were met by police with tear gas and clubs. Message from Jackie Robinson. Important, sent to, of course, the president. Important that you take immediate action in Alabama. One more day of savage treatment by legalized hatchet men could lead to open warfare by aroused Negroes in America. Cannot afford this in 1965. And he was very influential in that period. Second march was organized for March 10th, 1965. Martin Luther King Jr. motivated the marchers to register to vote. Johnson did sign then later, a year later, the Voting Rights Act of 1965. Voting Rights Act of 1965 authorized the use of federal voting registrars. The law prevented states from changing their election laws without clearance from the national government. The law also prevented the use of literacy tests as a prerequisite for voting. And this law has been eroded somewhat by our current Chief Justice, unfortunately. And so the movement begins its end in 1965 to the 70s. There are the Watts riots, the race riots in the various cities, the Black Panther Party, the Black Power, Martin Luther King Jr. is assassinated, and the Nation of Islam. Yeah, that way too. So what are some contemporary civil rights issues, because they've not gone away? We all know about LGBTQ plus employment discrimination. You still can be fired for being gay, even though it's more difficult. Human trafficking. There's still police brutality. There's disability discrimination. If you are handicapped, you may face discrimination in the workplace. If you are pregnant, you may face discrimination in the workplace. If you are fat, you may face discrimination in the workplace. Voting rights and election reform. We need to pass federal legislation to end mass incarceration. We need to end gerrymandering, protect scientific integrity, eradicate racist policing and police brutality, end profiling of law enforcement, end immigration bans, strengthen government ethics, respond to white supremacist violence. And I could have in there ageism. I didn't put that in as one. If you're an older person, you may be discriminated against as well. Establish guardrails for presidential emergency powers, which are often abused and misused. And so that's the end of our discussion for today. I hope that you have learned and enjoyed, and look forward to more presentations next month. You know, I'd like you to do me a really big favor. If you would go down below and you would hit the subscribe and like buttons, you would encourage me to do a lot more presentations like this just for you.